interesting thing is the substation, I ran up to Stewart Street, and then I don't know which way it ended up at Beverly Street somehow. I remember when I was a kid, it was still standing. I remember the stations, they were made of copper, and they were beautifully constructed. Something we walked away with.
Is that broken? Before it gets broken worse.
Which one did I go with?
Right here.
The last one down there?
Yep.
Let's put it in the drawer. All they didn't nail it. They just put it in there and glued it.
There's nails in the back. I mean, I'm sure they're glued. Just someone banged it.
This way. Yeah. You go over there and get a rest. Don't break everything. Everything's worth like $100,000. We gotta be careful. It's all antique. Come on in here. Just sit around.
Yes.
Yeah, Mike Sullivan, you know,
I do not accept it.
is he okay?
He's an okay guy.
Trustworthy?
She's late.
We spent an hour on the phone
She wants us to hold it
talking.
12 minutes, which means a half
So,
hour.
that's very nice. Well, that's good to know. I have
I'm
supporters.
gonna ask a question, but we.
All right, Robert.
You so.
I promise.
Okay. For anybody who doesn't know, my name is Terri Klug Cafazzo. I'm chairing this meeting. With me so far, we have Councilor Jubeville who's here. The other councilors will be wondering, and I'm going to read a letter from the governor dated January 9, 2019 to the Executive Council. I'm pleased to nominate Terri Klug Cafazzo to the position of Associate Justice of the Middlesex Probate and Family Court. By the way, the Cafazzos were good at their family stuff. I don't know if you knew that.
They're what?
The Cafazzos were good at their family.
I will not hold that against them.
So, I submit this nomination for the executive consent of the Executive Council pursuant to Part 2, Chapter 2 of the Constitution of the Commonwealth of Massachusetts. I'm enclosing the nominee's resume for your convenience. Introduce everybody in the room, please, that came with you.
Good morning. Today I brought in support of my nomination my husband of 31 years, John Cafazzo, sitting right there. He's a Bentley graduate, and he is in the technology field. I also have with me my two wonderful daughters, Sarah Cafazzo, who is a sophomore at Amherst, UMass, studying public health. And next to her is my other lovely daughter, Nicole Cafazzo, who is currently a registered nurse at Salem Hospital. I'm very proud of both of them.
Do they know about the Reverend Roots?
I think we kept it a secret.
Go ahead. I'll go ahead.
And then I have my mother and father here. They've been married 58 years. And I don't think I would be sitting here in front of you without them. They've been great role models. Both of them supported the family outside of the home. My mother taught me how to be a mother and also a very independent career woman. I can't thank her enough. My father has been a school teacher for 45 years and recently retired. In contemplation of his retirement, he went and he decided that he wanted to study to be a deacon in the Catholic Church. And he did get inaugurated to be a deacon, and he's currently a deacon, and he performs homilies every Sunday at the Worcester County Jail doing public service. Also here in my support is Attorney Daniel O'Brien, that's sitting right behind me, Vincent Procopio, who works with me in Essex County Probate and Family Court, and Attorney Tatarian. He's a practicing attorney out of the Lowell area. Thank you all for being here. In addition, I have Chief Casey of the Probate and Family Court, who is here in support of my nomination. And I don't think I would be here without all his encouragement, kind words, and support. Thank you.
Okay, thank you. We're going to call your first witness. Is Attorney Wright here yet? I know
Yes, she's here.
Okay, Attorney Wright, you can stand right next to the nominee. Let's hear what you have to say.
Good morning. It's an honor to be here before you today. I'm very pleased to be able to speak to you about the nominee, Attorney Terri Cafazzo. Attorney Cafazzo and I have been colleagues in the Probate and Family Court for many years. I worked in the Essex Probate and Family Court for 25 years, first as a probation officer, then in a number of court management positions before accepting positions with Chief Justice Carey in the Probate and Family Court Administrative Office, and then in the Executive Office when she became Chief Justice of the Trial Court. Through these positions, I have the advantage of knowing Attorney Cafazzo from both a personal perspective, having worked side by side with her in the courthouse for many years, as well as from the perspective as an administrator in trial court management. I met her when she came to the court in 2000 after having been in private practice for a number of years. She was eager but patient to learn all aspects of her new position. She quickly became a leader in the registry through both her knowledge and actions. Over the years, she served as an administrative deputy assistant register and first assistant register, both high-level statutory management positions. In her current position as first assistant, in addition to assisting the register with managing court operations, she performs a variety of quasi-judicial functions, such as reviewing formal and informal probate petitions, accounts and settlements, and ex parte filings. Attorney Cafazzo's temperament, work ethic, and judgment have ensured that she's someone that court employees turn to for her expertise and advice. Over the years, she's been a mentor to many of the young employees of the court. She's been an integral part of Register Pamela Casey O'Brien's senior management team and has helped the Essex Court develop and maintain its reputation in the probate and family court system as the can-do court. They're never satisfied or complacent about court operations, but are model practitioners of the concepts of continuous improvement, always looking for ways to improve efficiencies. Whenever complicated new procedures or changes in the laws are to be rolled out, Essex is often chosen as a lead court, knowing that process efficiency and customer service are their highest priorities. Individually, Attorney Cafazzo has been chosen to participate in a number of initiatives over the years and has volunteered for some very challenging assignments. With this extensive experience in the Probate and Family Court, she's no stranger to the demands that are unique to this court department. She's been providing assistance and direction to attorneys and the many self-represented litigants that come to that court with some of the most heart-wrenching issues, often in the most challenging of situations. I know you are all well aware of the circumstances that bring attorneys and litigants to the Probate and Family Court. Unlike many of the other court departments, most people at some point in their lives have to come through the doors of that court. Good people going through some of the most difficult times of their lives. Many not able to hire an attorney. Most are looking for direction, sometimes a kind face, someone to listen to their circumstances and help them move to the next step. They come to the court with issues involving children and the appropriate arrangements for parental time sharing when parents no longer live together, for help with child support, for protection from domestic violence. They're parents who have lost a child and need to make legal and care arrangements for their grandchildren, families and others who have loved ones with mental health or substance abuse issues, or caring for elders and need to file guardianship or conservatorship actions. These are the people that Attorney Cafazzo has been helping for years. She's prepared for these issues. She's familiar with all aspects of the court's jurisdiction, and she'll not be surprised by the day-to-day demands of this court. As a judge, she will take on a much different role, but this extensive experience will serve her well. The knowledge gained through her legal training, her even temperament, and her commitment to service, as well as her intimate knowledge of the challenges facing the court, should give you the confidence that she'll continue to provide outstanding service to the Commonwealth in this new position.
Thank you very much. We appreciate your testimony.
Thank you.
Attorney Daniel Gibson, former assistant registrar, who the title was, retired.
Good morning. Thank you. I am the retired judicial case manager at the Suffolk Probate Court, and while I hate the title. I'm now senior trial counsel at Saruf Law in Boston. In 1979, I began my employment with the probate court. So I've been around for 40 years, both as an employee and as a private lawyer. I've worked with many, many judges, and I've appeared before many, many judges. And I know that this judicial candidate has what it takes to be an excellent, outstanding judge. As many of you know, a couple of years ago, my court, Suffolk Probate Court, was in a crisis situation. It was a volatile situation. The register was suspended. They asked for volunteers to come and intervene. Attorney Cafazzo volunteered to come to Suffolk, sight unseen, and walked into that very volatile situation. She could have said no, but in a selfless act, she put the probate court system ahead of herself. She came to Suffolk, she organized the employees, she trained the employees, and most of all, she encouraged the employees. And she greatly improved the system, and she complemented access to justice. I agree with Attorney Wright's summation of her qualifications. They're absolutely without reproach. I've watched her at the front counter. She's dealt with senior partners from major law firms right down to self-represented litigants who are scared to death to be at the court. She treated everyone with respect, with dignity. She confronted problems and came up with reasonable resolutions. She'd do the same thing as a judge. She's unparalleled with her skill at treating everyone with respect and dignity. She knows domestic relations and probate law equally as well, and that is something very, very important to me as a member of the probate trial bar. A judge who is well-rounded, who knows both sides of the court, not just domestic relations. She's extremely well-versed and accomplished in all probate areas, and my observations lead me to tell you that she has the demeanor, the temperament, and most importantly, the compassion to be an outstanding probate family court justice. As a member of the probate trial bar, I thank the governor and the JNC for recommending this candidate to you for consideration today. I respectfully request that this council approve and confirm this nomination forthwith. This confirmation will complement access to justice in the Massachusetts Probate Court. Thank you.
Thank you, Councilor Drew.
Thank you for that. Let me ask you, you were down at the Suffolk Court when the registrar was suspended.
Yes, sir.
You agree with that?
With the suspension? That was a decision made by Civilian Court Administrator Harry Spence and Chief Justice Casey.
Right,
So
I'm just asking you as...
I agree that the court was in crisis and it needed intervention, and Attorney Cafazzo provided that intervention and really stabilized the ship.
Well, the registrar is back in business, isn't he?
Yes, sir. As of October, I believe, 2017.
So he didn't do enough to get removed by the SJC from that position. And the voters put him in that office, right?
Yes, they are. That is an elected position.
So, I don't know. I guess I look back, I don't know why he was suspended. If in the end he didn't do anything wrong, why couldn't somebody have been put down there to help him without suspending him?
Well, those decisions are made, well above my level.
I know that, but I'm just asking you. You've been there. Do you think they could have handled it differently?
I don't feel like I'm in a position to second guess my Chief Justice and the Civilian Court Administrator. I have to abide by their decisions and go forward with my goal of, complementing and making sure that access to justice is there for all court users.
And what did this nominee do down at that court?
She reorganized the staff. She put the staff in what are called pods or groups dedicated to each judge, so that each pod of registry workers knew exactly what needed to be done for each individual judge. She organized the front line, she trained them, and she encouraged them.
And how long was she down there for?
My memory is approximately a year, give or take. I can't remember the exact dates.
Was there another lady down there from Worcester that went down there to try to square things away?
Anne Marie Passanisi was there for a while from the chief's office. I don't remember another acting register from Worcester.
She was nominated for judge.
Right. I don't think she was down there. I think she was just part of the decision-making process.
All right, thank you.
Okay.
Thank you very much.
Thank you very much.
Okay, that'll close the witnesses in favor. Is there anybody here in opposition? I know there was a one on security. Ladies, check for me if there's some opposition out there. Call for opposition. We'll take your statement, please.
Good morning, counselors. Good morning, everybody. I am truly honored to be sitting here today in front of this council and in front of my family and supporters. Being a public servant, I can appreciate your dedication to this important process, and I would also like to thank you all for making yourselves available to me prior to this hearing. Your due diligence is admirable. I'd also like to thank Councilor Kennedy for being my host. I'd also like to take the opportunity to thank Governor Baker and Governor Polito for finding me worthy of this nomination, the Joint Bar and Judicial Nominating Commission for advancing me in this process. And I also want to express my gratitude to Chief Counsel Povich and Attorney Sharon Casey, Director of the Executive Nominating Commission, and Deputy Counsel and their staff. Lastly, I'd like to thank Attorney Wright and Attorney Gibson for testifying on my behalf today and their kind words in support of my nomination. So going through this process gave me the opportunity to reflect on my life's journey, both personally and professionally. For me, it has been both enlightening and humbling. I was not born in Massachusetts. I was born in Akron, Ohio. I lived in Kent, Ohio until I was 6 years old. I was actually living there when the shooting on the Kent State campus occurred. Although I was only 6 years old, the memory of helicopters in the skies, National Guards armed at street corners, and National Guards on my bus that I took to school every morning will be forever ingrained in my mind. It was a scary and unsettling time. I now have come to realize that that horrific event was a result of differences in political ideology, which has instilled in me the importance of being accepting and understanding of other people's opinions and viewpoints. My family then moved to a small town in Kentucky when I was in elementary school. So today if people ask me where I'm from, I would say Kentucky because I have fond memories of growing up there. While living in Kentucky, I was among the first group of students who were forced bused to Louisville Interschool System. It was an hour away from my home, where once again National Guards were posted on my bus. I experienced hatred firsthand when people threw bricks and rocks at our bus, and at times even gunshots were fired. But in spite of the violence and the hatred, I went to school every day. The experience taught me a great deal about the importance of embracing diversity and being inclusive. After attending Eastern Kentucky University for 1 year, I moved into the Boston area. This transition was somewhat difficult for me, from moving from a rural type of life to a fast city-paced type of life. While attending Boston College, I found the studies to be a lot more vigorous than that at Eastern Kentucky University. And some people there would comment on my slight accent because they thought maybe I wasn't as bright or well-educated coming from Kentucky. As hurtful as that was and as vigorous as those studies were, it didn't discourage me. I continued on, graduated from BC, and then went on to law school. I believe these personal experiences, no matter how small or insignificant they may seem to some of you, they have shaped who I am, what I do, and how I treat people. As for my professional career, I enjoyed practicing law for 10 years, trying cases and representing those people that might not ever be able to afford representation. I have also dedicated the last 18 years of my legal profession to public service, working in the probate and family court. For me, nothing has been more rewarding, helping families, individuals, and children get through a very emotional, difficult process. Sometimes they are in dire need of assistance. Sometimes they just need a kind word or reassurance that everything's going to be okay. And I found that rewarding. I believe that what I do in the probate and family court on a daily basis makes a huge difference in the lives of those people, court users, and the quality of justice of the probate and family court. When my nomination was announced, it was very humbling, to say the least. I received outpouring support, kind words from past clients that I had, past litigants that I've helped, and how I impacted their lives. I've also been reached out for colleagues, co-workers, judges, all recognizing my hard work and dedication. In closing, I hope that sharing my personal and professional experiences with you provided you with some deeper insight of who I am, my character, and what kind of judge I would be if this council found me worthy to be confirmed. Thank you.
I just want to introduce Councilman Maron Castillo to me. Councilman Castillo, do you have any questions?
I do. Let me ask you, you've been an assistant register, that's like an assistant clerk, right?
Correct.
For quite a while.
18 years.
Okay. And tell me why that makes you qualified to be a judge.
Well, I'm in the probate and family court every day working very hard. Part of my job is to do quasi-judicial functions under the MUPC. I review and make findings on informal probates and formal probates. I review and allow conservator accounts and estate accounts. I'm also very familiar with the types of issues that come before the court on a daily basis. I help attorneys daily. We discuss cases, how they should be handled, and I think that gives me a little bit more insight into what actually goes on in the court on a daily basis. It's almost like I'm not going into it blind. I have my eyes wide open. I know the challenges that face the probate and family court and the judges that sit there, the volume of cases that they have, and the variety of cases they deal with. And I'm very confident that that 18 years of experience will serve me well if you choose to confirm my nomination.
Yeah, I do think it's a unique situation to be in a courtroom every day in front of a judge or doing your own hearings without a judge that you're entitled to. It does give you insight that most people don't have. So I don't think there's any issue with me on the fact that you're an assistant clerk. But let me ask you some other things. You've done criminal work.
Yes, I have.
And tell me about that.
Most of my criminal work during my 10 years of practice had involved operating under the influence cases, some type of drug cases, assault and battery cases, 209 restraining orders. Those are the ones that come to mind.
You think that's going to help you?
Well, I do think it's going to help me in the respect that I do know the decorum of the court. I do know the rules of evidence, and I actually have been able to apply the rules of evidence in a trial setting. So I think that will serve me well as a judge. I know how hard it is to impeach a witness with a prior inconsistent statement. I know how to keep prejudicial evidence out. So I would feel that I could rule appropriately on objections before the court.
The probate courts are extremely busy, from what I know. I don't do any probate stuff. I did many years ago. A few things. But you get 60, 70 cases a day in your courtrooms.
Sometimes.
How are you going to handle that many cases to make decisions on? You only have probably 10 or 15 minutes each case to make decisions about whether somebody's going to see their children or have custody of their children.
I would make it a point to use the managerial skill set that I've acquired as part of my job as a first assistant register. I manage court's process, and manage cases, so that I would utilize those skills to help efficiently address the volume of caseloads.
Do you think that if there's no issue between the husband and wife, father and mother, in a case that they both should have equal visitation or custody of the children?
I believe they should have shared custody, yes.
And are you going to be a judge that makes sure you can do that?
Yes, I will.
You think it's important for both parents to be involved?
Absolutely, very important for both parents to be involved with that child. It's the best interest of the child.
Is there a dress code in the probate courts?
Yes.
There is?
Well, on our pretrial notice and order, it does say proper dress required.
What does that mean?
To me, it means business casual. Not necessarily a suit and a tie, that would be nice, but business casual.
And who made that rule up?
I don't have the answer to that question.
So, what if I'm coming to the probate court, but I don't have business attire? What do I do?
Well, as long as you're dressed appropriately,
Well, what's appropriate in your opinion?
jeans, a shirt, shoes.
What if I come in a pair of shorts?
I would think that would be inappropriate in a court of law.
Really? What if that's all I have?
Well, then I would excuse that as not being inappropriate.
You would agree with me that there are some people that don't have funds to buy,
Right, you have to be sensitive to that, yes.
and some people are never taught how to dress, right?
Correct.
And some people come from different cultures where they dress differently than
Correct.
I would or you would, right?
Correct.
And are you going to, what are you going to do about that? You're going to single them out and tell them to go back and get dressed appropriately?
If that was a part of the culture or the way they dress, I would accept that that's a part of their culture.
I mean, I see people come to court a lot. They have a T-shirt on. I wouldn't wear it to court, but sometimes that's all they have.
True.
So what are you going to do about that? Let's say I come in with a T-shirt and that's all I have. What are you going to do to me? Anything?
I would be inclined not to.
When you say that, that means you might. Or is it 100% you won't?
Well, it's 100% that I won't.
I'll tell you why I asked that, because we had a judge here for the probate court who said that people that came dressed, and just to go back a minute, I don't know of any rule or regulation in the entire court system that has a dress code by law.
Not by law.
And the fact that people show up is probably the most important thing, isn't it?
Yes, it is.
So this candidate said in an open session that she thought that anybody that came to a court dressed inappropriately would be disrespecting the court. And she would either send them home or fine them. Do you know of any law that gives the judge the right to fine somebody because they're not dressed appropriately?
No, I do not.
She also said that the other thing that bugged her was lawyers that come late. So I said, well, what if a lawyer has a scheduled court date in front of you, but he leaves court and comes back, he's got another case, so let's say up in Essex County, this woman was going to Middlesex. She went to Middlesex, she's on the bench now. I did not know her. And she said, no. I said, what if he calls the court? She said, it's going to be late, I got to go to Essex for a plaque. No. So what do you do about that? He said, I'm going to fine him.
Well, I would not. I can appreciate, as a practicing attorney, trying to be in two places at one time, and that if I had the courtesy of a phone call explaining why, I would be sensitive to those attorneys and their need to be in two different places and call them later in the day.
So, do you know of any law that says you can fine a lawyer because they're late?
No, I do not.
And isn't that
Yes,
If you have 60 cases in a day, you're there till 4:30, no matter what,
correct,
right?
correct.
So I called up recently, maybe 6 months ago, to a court in a criminal matter. And I said, it's a pretrial. It wasn't on for trial. And I said, I'm going to be a little late. I have to go to another court first. So the person said, well, where are you going? And I said, well, why do you ask that? Well, because the judges like to know where you are. I said, why? He said, that tells me that some judge is thinking defense lawyers are not being truthful with them, so they're going to probably call some court. I said, as far as I'm concerned, I'm calling as a courtesy to tell you I'm going to be late. I'm not calling to get permission to be late. I'm not charged with a crime. The defendant will be there at 9 o'clock. So there seems to be this push that we got to know where the lawyers are and what time they're going to get here. I said, how do I know what time I'm going to get there if I'm in another court? I don't know what time a judge is going to call my case and let me go. So my point is that whether you take my case in probate court at 10 o'clock for 15 minutes or at 3:30 for 15 minutes, you got a lot of business there that day.
Correct.
Right?
Correct.
And as I said to the lady in this particular court, I said, am I the only case on today for a pretrial? She said, no. I said, well, what's the problem here? So, as I said, the other lady that was here is now a judge, said that she would fine lawyers for doing that.
I would not. I can appreciate,
And you don't know of any laws that gives you the right to do that.
I do not.
Let me suggest to you that there isn't. And let's assume that you did that. I said this to this lady. Let's assume I'm stupid enough as a lawyer to give you, let's say, $100 that you said you would fine me. I said, what are you going to do with it? She didn't have an answer. Are you going to put it in your pocketbook? She said, no. Everything in the court is pigeonholed money-wise to go somewhere. What are you going to do with this? I don't know. So I said, let me get this straight. Now, you're in a court where there's 60 cases, 70 cases a day. You're going to spend the first 2 hours telling people they're dressed inappropriately, according to the way you think they should be dressed, fining them, and then you're going to fine lawyers that are late. So I hope if you get this confirmation, I'm not going to hear stories that you're fining lawyers or you're berating citizens that come into your court because they're not dressed the way you think they should be.
I can assure you I won't. I'm sensitive to their needs and situations.
Thank you. That's good.
Thank you, Counselor.
What else did I want to ask you? So you've had experience with conservators,
Yes, I have.
and what do they do?
Conservators are appointed by the court to manage an incapacitated person's financial situation.
Okay, and who appoints them?
The judge appoints them. People petition. It could be a family member or it could be a court-appointed conservator.
And what's the difference in that and a guardian?
A guardian is only over the person, their medical issues, their daily care, versus the financial issues.
So, if you've got a contentious divorce with allegations of different things going on between the parents, can you appoint somebody to go out and do an investigation on that?
You could appoint a GAL, yes.
And what do they do when they go out? Do they get paid by the court, or how does it handle that?
It depends on the family. If the family has financial means, then the family would pay. If not, the Commonwealth would pay for that appointment.
And are there court-appointed lawyers in probate court now?
In certain types of cases, we appoint attorneys in adoption cases for child, bio mom, bio dad. We've just started appointing attorneys for bio moms and bio dads in guardianship of minor cases.
What are you saying, bio?
Biological, excuse me.
Oh, okay. I didn't get
I apologize.
Huh?
I'm just too used to the court lingo. I apologize.
The probate. Okay, so, if two people come into the court but they don't have any funds, they don't automatically, like in a criminal court, get appointed an attorney, do they?
No, they do not.
Can they ask for one if they?
Well, because there's no incarceration involved with our courts, you know, they don't have that right of counsel in the civil court.
So, you're gonna need a lot of patience to be a probate judge.
Yes, you do.
Do you have patience?
I believe I do.
Should we ask your daughters that?
No, please do not. Don't put them on the spot. Of course they're going to say yes.
Do you ever lose your temper?
Not normally, no.
You've never lost your temper?
Not normally.
Well, what's that mean? That you
Has to be- you know what?
You're starting to sound like that guy that was in the Senate yesterday for the AG's appointment.
Isolated incidents, I may lose my temper in isolated incidents.
You know, I've been here a little while now, and we've got a lot of women sitting in that chair, and everybody says the same thing, she's never lost her temper. I said, you know, all my life I've looked for a woman that didn't lose her temper. I had to come here to find them. So, it's a stressful job.
Yes, it is.
You make important decisions on people's lives, your children. Are you going to be able to handle that stress?
Yes, I will.
And remember that the citizens that are before you are paying for all of us, our salaries and our benefits. So treat them good.
I will.
Promise.
I promise.
I see the great Register of Probate in Norfolk County, Pat McDermott's here. In support of you, I would imagine. Thank you very much. I appreciate it.
Thank you, Counselor.
Thank you. Well, I was on a road where they had an accident, not a good start to the day. Thank you for the time that you've afforded me. I really appreciate all that time.
Good morning.
First of all, I have to tell you, in 20 years, you're the first person who hasn't been a practicing lawyer for 18 years. I don't quite understand all of your duties, and I'd like to know how they compare to being a practicing lawyer for 18 years and being away from representing clients. So, first of all, I ask all the nominees about process. I'm really concerned about that. So tell me how you applied and
There was a position for a circuit justice at the Probate and Family Court posted in August, and I applied for that position in August.
And when did you get a call to be interviewed by the J&C?
I believe the beginning of October.
And how many people were at that interview? How many members of the Judicial Nominating Committee?
I believe it was 10.
10. You know, there's 21.
I do.
So that means 11 people recommended you who never saw you, never met you, never talked to you. I live by the Serenity Prayer, okay? This is the first administration that has allowed that. Well, that's the first J&C. Mr. Dacia, who does it that way. But anyway, so there were 10 people there. All right. So now, in your questionnaire, it asks you to list the last 5 cases that you've had. And this is just about procedure, not anything, critical. But when it asks to list all law firms which have been associated during the last 5 years, the answer isn't non-applicable. It's either you have and you name them, or you say, no, I have not been associated with any law firms in 5 years. Just, I don't know if you're ever going to fill out any other more applications, but you read the question. It's not applicable as an appropriate answer. Either you did or you didn't. But the question is applicable. It is applicable for me to look and see, okay?
I understand.
So that's just information. I want to know, it's really, this is new to me in 20 years. I haven't seen this. So I want to see how your work experience compares with being a practicing lawyer. So tell me, managing the operation of the court, what do you do?
We manage case processing. We take in the filings. We review the filings for accuracy. We make sure that they get placed on the record.
You say we.
The people that work at the probate and family court and the registrar's office.
Okay, so you do that jointly.
Correct.
Okay, you give advice to self-representative litigants and attorneys. Tell me about that.
Yes. The probate and family court practice, they come to us for advice on maybe procedure, jurisdiction, subject matter, how to deal with certain issues, whether it be emergency custody, or how to process a guardianship of a conservator, or how to process an estate. So we're there to help guide them through the process. And in order to do so, we need to know the substantive law that goes with that.
Okay, I don't know the jargon that's used. Perform quasi-judicial functions as a clerk magistrate. I know the clerk magistrate, but I don't know what quasi-judicial functions are. Could you tell me about that?
Well, those are matters that used to be done by judges alone, but have delegated that to the clerk magistrates under the MUPC so that they can go through the wills, make sure that they're valid, allow or deny the petition to be appointed, make findings of fact that proper notice has been given. It's kind of to take some of the burden off the judge's volume of cases.
So when someone goes before a clerk magistrate, they go before you? You're the clerk magistrate?
I am, but it's not an actual session. They bring their papers, we sit down, I review them, we go over them, and I either allow or deny their petition.
Why is it quasi-judicial function? Why'd you put that? You know why? Because I have 20 years I've been sitting here and I've never seen that, so I want you to educate me. Why couldn't you say you're just a clerk magistrate? Were you a clerk magistrate appointed or quasi?
Yeah, I was appointed under the statute by the first judge of the court, yes.
Okay. Tell me quasi-judicial. How is that different from being a clerk magistrate than performing quasi-judicial functions?
I think all clerk magistrates do quasi-judicial. You're not fully a judge. You just make findings of facts. You can't use discretion, the matters that we deal with. So that's why it's not fully judicial.
I mean, you go before a clerk magistrate, the clerk magistrate makes a decision and you go on your way.
Well, that would.
Where are you?
I'm not like a clerk magistrate in the district court, no. If
Is
that's
it
what
different in probate court?
It's different in probate court, yes.
Okay. Manage court sessions. Tell me what you do.
Actually sitting in the session with the judge while they're conducting either a trial or a motion session, organizing the docket, calling cases, swearing people in, that position in the court.
Okay, so you really have no connection with clients. You don't have any for 18 years, so there's no clients involved in this. What I wanted to know is, I know that there is a backup in the court and everyone's there with their clients at 9 o'clock. Did you do something to change that?
We're in the process of trying to change that, yes.
Okay, because it said you already managed that. That's what I thought maybe you had done, implementing efficient case processing.
Yes, we've done that, but we're continuing to improve on that as well.
Okay. Do you think the court has changed since you have been a practicing lawyer, 18 years? A lot of things change.
I think laws have changed somewhat, at least in the probate and family court, they have changed.
A lot of legislation here has changed.
Yes.
What do you feel about the, having the juvenile court age moved up? There's a appetite here to do that.
Can you repeat that?
Are you in favor of increasing the age of the people that go to the juvenile court, the juveniles?
Well, that's not the court that I worked in, but if it's to lessen the load of the district court, I would be in favor of it, if that's the reason. But I'm not familiar with
Wait, say that again. You in favor of why?
if it's for managerial reasons. Other than that, I
It
wouldn't.
would work the opposite.
So then I
work
would
the
not be in
opposite.
favor. Then I would not be in
The
favor.
juvenile court, I know, I looked into it, they are overworked. If you want to increase that age, you're giving them more work to do.
Knowing that, I would say no, I'd be against it.
Well, I wanted your opinion, not mine. The other thing is, we have seen some horrific rapes and murders of young people raping and killing a teacher and so forth. You know those cases. So I don't know what would be, what would be the better case to change it. So that's my opinion. Okay. Did you vote on the marijuana law?
Yes.
You did. Okay. Okay, do you think that there was enough investigation in how they would proceed with this?
No, there was not.
No, there wasn't. That's why I voted no. I'm concerned mostly about the police. Police can't determine how much marijuana someone's taken. I'm in favor of medical marijuana. I have a friend who has cancer and it's helping him. I'm 100% for that. The other thing is I'm very concerned about edibles. They're not even addressing that. And last year I read about a 15-year-old boy on a school bus and someone gave him gummy bears. And it said that it's supposed that the marijuana doesn't take effect in the body with taking edibles as fast as it would with a cigarette. So he kept eating them and eating them. And finally he went into some kind of convulsion or whatever and was taken to the hospital. There's no regulation when they put this on the ballot of how any of this is going to be taken care of. And not everybody is, how can I say, responsible. If you just read, and I read this, a police officer left his gun in the pocket of the backseat of the car, and a 7-year-old shot himself. So they're good people, but they're not always mindful of what they should be doing. So I'm thinking of someone who has edible chocolates on the counter in the kitchen, and a 5-year-old takes it. So I shouldn't be giving you my opinion. So I appreciate that you voted yes, and that it has no basis in how I'm looking at your appointment. So have you had 209As?
Yes,
Where? Now, see, we've got to go 18 years back or here or what?
both.
Okay. Well, how do you deal with it in your quasi-position in court with someone like that? Tell me what your position would be.
To take in the paperwork on the 209 and make sure that it's complete and get them before the judge.
Okay. So you assist the judge?
Yes, I do.
In your job. Okay. Have you had many cases with drug addiction?
There's a lot of cases in our court that involve drug addiction. That's why there's an increase of guardianships of minor cases, increases in divorces, and so in that respect, yes.
When we met, I told you a case, and so you already know my opinion, but I'm going to ask you, have you had removal cases?
No, but I understand the high standard that's required in order to allow a removal from the Commonwealth.
Well, we only have one counselor here, your chair. Counselor Kennedy was not present. Probably 19 years ago, we had someone come, a nominee for probate. And I was heartsick when I read a couple of years later about actions she had taken. And it was a removal. And the case was a husband and wife who were divorced. The husband was loving, wonderful father. He lived close to the home. I investigated this, and lived close to the home. Saw the little, there were toddlers, the three of them, and he saw them nearly every day. And even Christmas Eve, he would come to the house and stay overnight so that he could see them when they got up in the morning. She petitioned, the wife petitioned the judge in the probate court to allow her to move to Oregon, across the country, with her 3 little children. She had no job waiting. She didn't know a person living there, no family, no friends. And to me, it was vindictiveness to separate the relationship with the father and the children. And I almost cried. And you know what she allowed? Visitation should be thrown out, shouldn't even be used, but she gave visitation rights to the father, who was in the paper, 6 to 7 on the computer, on the internet, with his children. You can't hug a computer, so he's lost all relationships as a father. And I thought, I hope that isn't the wave of the future. I don't know whether it's happened again. I haven't heard. But it is disturbing, and I just want, if you do get appointed, I want you to follow the rule of law and the criteria for removal. And a lot's going on now in the court that really bothers me, what judges are doing. I don't have a crystal ball. I don't have a crystal ball when, well, I can't even get into some of the conduct that they've been involved in. So how do you deal in your court with a citizen and a non-citizen who will come up before you with the same situation? Do you look differently at the non-citizen because it could result in deportation or whatever than the citizen? How do you deal with that?
And the citizens, I would treat them fairly and equally.
No, we had someone in Salem that didn't. Isn't that right? Yeah, I think we should follow the rule of law. All people are equal, and everyone should get equal justice.
Right.
Now, answer me honestly. How do you feel you are more qualified, not being a practicing lawyer for 18 years, with your work experience, and I'm not dismissing that, what you're doing, than someone who has gone to court 3 or 4 times a week for the last 18 years and has had all kinds of criminal cases and removal cases, all of those things, custody cases. How do you compare?
I think I'm just as qualified, and I think that the fact that I have been in the probate and family court for 18 years gives me an advantage in regard to transitioning, in regard to knowing on a day-to-day basis the volume of the cases that go through there and how to manage that and how to deal with it. I also am very knowledgeable on the substantive procedure laws that on the case that our court deals with, because I do it every single day.
You know, when we met, we talked about excuse me. When we met, we talked about, now I lost my train of thought. We talked about how our society has changed. The definition of family has changed. And there's no case law that you could go back 40 years ago to address these things that come before you. We talk about same-sex marriage or a relationship. And what if a same-sex, two women are not married and they live together, and one of them is a biological mother of their child. Now they're going to separate. How do you deal with that? Does the biological mother have more rights under the law, or how can you treat it equally? What do you do?
You treat it equally if they file a complaint in equity to declare the non-biological parent in that situation as a de facto parent. And then if they're declared a de facto parent, they can have the same rights and privileges as the bio parent.
Is it any different if they were married?
I would treat them the same if they were married. In that case, you wouldn't have to go
Okay,
through
so if you're
the
not married, you still have the rights to being a married parent.
if you get declared to be a de facto parent, yes.
I mean, there are things in this time that have changed that maybe come before you. I don't know if it ever has. What about if a couple are married, man and woman are married, and the woman feels she's not ready to have children, but she wants to have children, so she has the eggs frozen. And this is a mutual agreement, husband and wife, that when she is ready, then they will have children. Now the woman is divorcing the husband and wants to destroy the eggs. How do you deal with something like that? What case law? I don't understand.
It would be determined in equity, under equity powers, and I would be inclined to destroy the eggs because they're no longer going to be married, and the intent of freezing them is no longer the same.
So there is no law to protect the eggs that's not involved in this at all?
Not that I'm aware of.
Well, I think the whole thing would be, as I said, in 20 years, I've never seen someone come before us that hasn't been a practicing lawyer for 18 years. So I have to really figure out all your work experience and compare it to someone in court 3 or 4 times a week, because I serve with people that do that, and I know it's serious, and they're dedicated to their clients, and it's very time consuming. It seems like, and correct me if I'm wrong, you're really in a managerial position.
That's only part of my function as the first assistant registrar. That's part of my function.
And you'll have to excuse me, because in 20 years I've never seen anything like this, and I'm really, really trying to understand. And and I said to you, I was kind of surprised that you applied to the probate and family, because as a practicing lawyer, you had 60% in the district court.
Correct.
And to me, if you're going there, and you must have gone there a number of days in a month for 10 years,
Correct.
that would be where your expertise lies in the district court. And you only have 20% in the family court. And so, I'm just trying to learn, so I hope,
Right.
I'm not trying to be offensive anyway, but that to me came out. Because usually when I look at the questionnaire, it's where that person has practiced the most. And you practiced up until 2000, so you had 10 years in the district court. So tell me why you didn't apply to the district court. That's your experience, that's your cases you had. And you know what? I love private practice. I told you that. I love it because you choose your clients. They're not given to you like an attorney general or district attorney. They're halfway there when the police gives their report. And I don't demean them. They do their job. But I'm saying you have to choose the person you're going to represent. So that means a lot to me, and 60% is a lot.
It is.
So,
The reason I chose to apply to the Probate and Family Court is because I've worked there 18 years. I'm very knowledgeable in process, the laws, the cases, the types of cases, and I've also developed a passion for that court and helping the people of that court. And I think I have a positive impact on them every single day. And I think if confirmed to be a judge, that I think I can even have a greater positive impact on those families that come before me.
And you know, I like you, I've met you, and I think you are, dedicated, and I like all the background. And so, as I said, it's a matter of comparing your work experience with versus being a practicing lawyer. And as I said, I've been here 20 years and I've seen a lot of changes in legislation, some good, some bad. I have testified and I'm, against mandatory minimum sentencing, and a lot of those things have changed, and I think that's a good thing. But it's just different for me to look at this because I like you, and I think that you in your private practice, you must have been a great lawyer, and you were really dedicated, and I'm sure you're dedicated in this job. I know that, and from talking to you, your heart's in it. So it was a pleasure to meet you and to take that. The other thing is I would suggest that you sign page 10, because this is where you swear and affirm that under penalties of perjury that the information is such and such, and you didn't sign it, didn't put a date. So I just suggest you
We'll make sure that's done before she leaves, Council. I didn't pick up on that, but I will make sure she signs it before she leaves. And you all set?
I'm all set. Thank you very much.
Thank you. It was a pleasure meeting you,
Really,
Counselor.
no, I did, and I really like you. Thank you.
Thank you.
Council, I know.
Thank you very much. Good morning.
Good morning.
I read your material. I talked to folks. At this point, I don't have any questions.
Thank you, Counselor.
Okay. Council Casey.
Thank you. Good morning.
Good morning.
Nice to see you again. Thank you for the time that you afforded me when we spoke about your credentials, your background, your expertise for this position. Just a couple of questions. We covered a lot of material when we met, and a couple comments. I look at your materials, and I see that you practiced in the district and superior court, criminal and civil, for 10 years before taking on the more administrative positions that you've had and that you have now. Can you tell me how many trials you think that you've had during that 10-year period, either in district court and in superior court? And the number can include both criminal and civil.
I would approximately 40, and that would be about 4 a year that I tried during my private practice.
And what was the longest trial that you can recall, or most complex, and most complex?
The longest trial was a 2-week trial, but I think it was because there was 4 co-defendants on that trial. And then the next one after that would be the civil case where I sued the city of Beverly. That was probably the second longest.
How long did that last?
A week.
So what was, when we spoke, you appeared in federal court on a case. Can you tell the council a little bit about that case?
Yes, I was involved in federal district court on a forfeiture case. Client of my money got seized at the airport, Logan Airport, saying that they were proceeds from a drug sale. We petitioned the court for the money back in federal district court, and the judge awarded the money back to my client. However, the U.S. District Attorney appealed that case, and I found myself arguing this case in front of the First Circuit Court of Appeals. It was a very exciting experience. I'm glad I did it. It was a lot of work, getting your appellate brief together, doing your oral argument, and unfortunately, the court did not agree, and the money was forfeited.
We've actually voted, I recall a nominee, Council Kennedy was here, Council Einella, I believe Council Hurley was here, but that forfeiture issue was an issue that we had talked about in this chamber as something that, the federal government tends to overreach in there. And particularly now, this discussion about reviewing some of those forfeiture laws and how unfair they can be. And we had a nominee who actually got voted down by this council, where they went after an injured spouse. The husband had committed suicide under the stress of the federal case, and the feds tried to swoop in and take her home. I believe the son also hurt himself, or they had a young son, and so those cases are real tough. So when we spoke about that case, I know that they can be pretty intense, and there's a lot usually at stake for families. With respect to the probate and family court, I think that there is a fair amount of overlap with what you have seen as a district court practitioner, and specifically in the areas of restraining orders. Can you speak a little bit about your experience with restraining orders, both in your capacity as a litigator in the district court and in your function now as administrator?
I've defended restraining orders in the district court, and I've been successful at getting them vacated because it seems that they're overused, they overreach, and they use it for some type of leverage in the divorce case. Some of them have been in combination with divorce cases that I was handling, and some have not.
And have you dealt with that in your position now as an administrator, receiving restraining orders? Is that in a different area?
I review the restraining order applications for accuracy and make sure that the affidavit is filled out correctly, and I send them to the judge for them to decide.
And based on your experience in the district court and your current experience, do you think you can conduct a hearing where you can really drill down and get to the bottom of who's credible and whether there is a fear of imminent serious physical harm to satisfy that high standard?
It is a high standard, and I do think I have the ability to do that and assess credibility, through demeanor, through testimony, through inconsistent statements. I don't feel like I would have a problem with that.
Thank you. I think the fact that you have experience in the district court with restraining orders is such an asset for somebody who would go into the probate court. In addition to criminal law experience, whereby if somebody comes before you and they've only merely been accused of a crime and there hasn't been a trial and there hasn't been a conviction and they haven't had an opportunity to even file a motion to dismiss, a motion to suppress, you're not going to have the same reaction, I think, potentially prejudicial reaction to a party who appears before you in those situations, which are not uncommon, where you have a divorce, sometimes you have the domestic charges, you have the restraining order, and then they end up before you. So I think that'll give you a real good view of those cases in a way that you're not going to overreact or overreach.
I agree. Thank you.
How many people work on you right now? How many people answer to you?
Approximately 30 people.
And is that on a daily basis that you would interact with those 30 people now?
Yes, it is, on a daily basis.
And I think that's important too, because you're going to be working with colleagues, you're going to be working with court staff. I think it's important to be able to work with people in a collegial manner, in a professional manner. And some people coming right out of private practice, in a firm like mine or Council Kennedy's, you have one or two lawyers and a couple of people that work underneath you, and I think it's a whole different atmosphere when you go, if you are concerned, into that type of setting. So
I can tell you, Council, I went into the probate court in Salem, and everybody in there was very excited about it.
I'm sure that they were. Well, what I would just say in closing, because we did cover a lot, I know your philosophy about custody and people walking to your courtrooms, mom and dad on equal footing, and that's how it should be. I would just say that I know one of the concerns that some of my colleagues have that you haven't been in a courtroom litigating. You've been in a courtroom in the last 18 years.
Correct.
That's for sure.
Correct.
You just haven't been in there as a practicing litigator. But I would say that the fact that you've had about 40 trials over your career in criminal and civil and district and superior court, and the fact that you've had trials that have lasted up to 2 weeks, is more trial experience than some of the probate and family court nominees that we see come before this council who walked out of court yesterday as practitioners for the last 18 years. You've got more trial experience than some people that this council have voted for and put on the superior court. So that doesn't bother me at all. And quite frankly, I think that the nature of your experience in court is something that you keep with you. Catching up on statutes and regulations and case law is something we all have to do every day. You know, whether you've been in court yesterday or like Councilor Kennedy this morning, you know, that's just part of the gig. So I'm very impressed with your materials, and your background and all the things that you've done. I think you're a great fit for the probate and family court. It doesn't hurt that you went to New England School of Law, right, a great school. And I guess I would just say in closing, congratulations to you and your family, and I think it's wonderful that both your parents are here. It's a very, very proud day to see you, so congratulations.
Thank you very much, Counselor.
Thank you. We talked on the phone at some length, and I just want to go over a few things. You indicated the last time you were in a probate court was when you observed a judge about 4 years ago?
At a trial.
At a trial?
At a trial. I think, yes.
Go ahead.
That I've been in the courtroom and on motion sessions or pretrial sessions, but I think the question was, last time I observed a trial in court, and that was about 4 years ago, yes.
All right. And basically, how many divorce cases did you handle and when?
During my private practice, I would probably say about 10, but none of them went to trial. They all were resolved.
Did you ever act as a sessions clerk in probate court?
The role that I played when we were short-staffed would have been the role of a sessions clerk or an assistant register, now called AJCMs, yes.
And how many times did you do that?
I've done it for Judge Kagan, I've done it for Judge Cronin, I've done it for Judge Stevens, Judge Kaplan, Judge Sahagian. I would say 24 times.
Okay, and how long ago was that?
Probably just 2 years ago.
All right. And what experience have you had dealing with pro se litigants?
I deal with pro se litigants every day when at the front counter when they have questions about process and procedure, how to get child support, what do I file. I deal with them on a daily basis.
So you're behind the counter?
At times I am behind the counter, but I'm also available anytime when I'm in my office. They come get me. I go out to the counter and I serve the litigant that is there.
In interacting with the 30 people, you don't interact with all of them every day, is that correct?
Well, we're all in a big group and we all interact every day, whether it be trying to resolve an emergency or just teaching case process or overseeing and supervising what they do. So we do interact every day.
Okay. And how many of those 30 people have work concerning divorce cases?
Well, in our court, we've cross-trained all our employees to be able to work all different case types, and it seems to be helping the case flow, because if you have one person dedicated to a specific case type, that case gets backlogged. So I'm proud to say that the Essex Probate and Family Court employees are cross-trained to deal with all case types.
All right, but on a daily basis, people have a job assigned to them, correct?
Correct.
There's people who deal with wills and estates, correct?
Correct.
There's people who deal with adoptions.
Correct.
There's people who deal with divorce cases.
Correct.
There's people who deal with non-support cases.
Correct.
All right, on a daily basis, on average, how often do you deal with estates?
How often do I personally deal with estates? I probably allow and review 10 to 15 estates a day.
Okay. on a daily basis? How many adoptions do you do?
Adoptions would be less. I would go over them, maybe 2 or 3 with the adoption clerk. I don't actually process them. We have an adoption clerk that does that.
All right, so the adoption clerk does that. On a daily basis, how many divorce cases do you deal with?
I would guess that in divorce cases, whether they're wanting to file a divorce or get get custody, I would say about 8 a day.
And in what aspect do you deal with?
Procedure.
Procedure is in terms of all the paperwork is properly filed, motions are signed to whatever date. But in terms of substance, you don't really deal with that.
We review, on the 1A divorces, we do review separation agreements. I do that, I only probably do that once a week. Because we have other people that are assigned to do that role as well. Because I'm not the only one doing it.
So non-support and custody issues involving unmarried couples. How often do you deal with those?
Probably 2 or 3 times a week when they come in on an emergency basis.
All right. What are the grounds for divorce?
There's a no-fault grounds for divorce, irretrievable breakdown, and then there's 7 fault grounds for divorce. There's adultery, desertion, impotency, excessive use of alcohol or drugs, cruel and unusual punishment, and gross and wanton disregard to support the spouse.
And it's no fault, it's a 1A and a 1B.
Correct. It's a 1A.
What's the difference?
The 1As are the joint petitions that the parties agreed upon their divorce, and they have a separation agreement already agreed upon.
What's a 1B?
A 1B is a contested divorce. It's a contested divorce. Contested.
And what are the grounds for annulment?
Fraud and the inducement of the marriage. If there was anything that was fraudulent before the marriage that induced them to get married.
And if they've been married before?
And that would be a grounds for annulment, yes.
Any others?
I can't think from the top of my head.
Now, you talked about 209As. 209As were enacted how long after you were in practice?
I can't recall.
The 209A, what are the requirements?
The requirements of the 209A that the petitioner needs to show that they're in fear of imminent physical harm. It's a high standard. It should be a high standard to meet.
All right.
In about a minute, we're going to have our assembly. So we're going to continue, we're going to recess the time it takes until assembly and the swearing in. Nobody leave.
But aren't we all done? Oh, just the, I'm sorry. Okay, sorry. No, that's fine. Those ones I should walk in.
I was letting people know, so just say it.
What if someone comes in? What if another council comes in?
Okay. Thank you. All right. Now, so you don't recall how many cases you did in private practice that were 209As?
I would say 8.
Okay. And over the years, there's been expansion of the case law concerning 209As.
Correct.
The findings the judge has to make.
Correct.
What are those findings?
They have to find that the plaintiff is in imminent fear of physical harm, and based on the facts that were presented at the hearing.
Okay, but what kind of findings do you have to make? Are you familiar with the form at all?
No, I'm not.
So I would suggest to you that you have to find things, for example, that there's still contested matters concerning custody, or that there is continued litigation that's going on, or can you think of some other ones?
I could barely hear you. Could you just repeat yourself? I'm sorry.
That's okay. So if I were to suggest that some of the findings that you have to make to support the issuance of the restraining order, or not to support the issuance of the restraining order, is continued custody issues,
Correct.
continued litigation, ongoing litigation, the types of threats that have been made. What are some of the other things? Anyone know?
I don't think I understand I don't think I understand your question. I apologize.
There was a case and a ruling that in order for a judge to issue an order, he or she had to make written findings. So I'm asking you if you are familiar with what those written findings are.
And I said I am not.
Okay. All right. Let's talk about Chapter 208, Section 34. Are you familiar with those factors?
In regard to division of marital property?
Division of marital assets, correct?
Yes, I am.
Okay. So what are those factors, and what do you believe to be the most important factors in a case that involves distribution of significant assets?
It depends. I think all the factors are actually important. The factors of age and health of the person, if the assets have been commingled, how do they use the assets during the marriage? Doesn't necessarily mean that it's 50-50. It's an equitable distribution. I think employability, future employability of a party. I think the income is definitely an important part of that. I think you can take into consideration the needs of the children.
In distribution of assets?
I believe so. Hold on. Yes, present and future needs of dependent children are also included under Section 34.
Okay. And is there also contribution of parties to the marriage?
Yes, that would be a consideration
And
as well.
What would constitute a contribution by the husband, for example?
If he was a high wage earner, his income contribution, maybe if he purchased a stock option, contribution that he made to a pension, they would all be considered marital assets and factors to consideration.
And how about with a wife who's been a homemaker?
Her contribution is what she's done in the home. That would be taken into consideration as well. What did the wife do at home? Was she a homemaker? Took care of the bills? Took care of the children? Those types of factors.
All right. And with the issue of custody, the trend now today is to consider joint custody with what they call shared custody.
Correct.
Okay. What would the effect of a 209A against the husband have on an order or a request for a shared custody situation?
There's a presumption that if there's a 209A and that there was, a history of abuse or a serious incident of abuse, the presumption is that he would not get custody. However, that presumption is rebuttable. For instance, it could be rebuttable that he has a good relationship with his children, he's not abusive to his children, the abuse was an isolated incident, the abuse was not observed by the children, it's in the best interest of children to have the relationship with the father, but it is a rebuttable presumption that they have to overcome.
All right. You're familiar with marital privilege?
Excuse me?
You're familiar with assertion of marital privilege?
Yes, I am.
So, in essence, can you compare and contrast the difference between marital privilege in a district court or superior court criminal case and in the probate court?
In the district court case, that spouse could assert the privilege and not have to testify against their spouse. But in the civil case for a divorce, that privilege is no longer available because there's no viable marriage.
In where?
In a divorce case, the marital privilege cannot be really asserted because there's no more viable marriage and they're going through a divorce. So it doesn't work the same in the probate and family court as it does in the district court.
All right. And if there isn't an assertion of marital privilege, and the wife begins to testify or ask the question, and what did your husband say about X? Can the attorney for the husband object?
They could probably object on the ground of hearsay.
Okay. And so for 18 years, 4 years ago, you were in courtroom observing a trial. Prior to that, how many trials did you observe in the district court, in the probate court?
Throughout my 18 years, I'm going to say 4. Four full trials.
Thank you. I have no more questions.
Thank you, Counselor. Oh, it's over.
Nice day.
Oh,
You know, next week.
I didn't even say thank you, goodbye, nice to meet you. Okay, well. No, it's okay.
And they won't close the doors because people come and go with their flash cameras. We could always close these doors. We could always close these doors. That becomes like a riot.
Oh, what they want. Oh, they want the truth. Yeah.
How you doing, Mike? Nice to see you. Have a ticket, Ashford? We have, That's about it. Okay. Patrick, can I move these? I know, they'll be here signing, they're gonna knock them on the ground. So the two reps up here signing.
On yours?
Thanks. Thank you very much.
It's not the only one.
Yeah, me too.
George, you start.
Okay. Oh, yeah.
Mary, how's the knee doing?
I'm able to walk up and down stairs alternating,
It's good.
but I still gotta hang on and use the cane for that.
It's all right. And it will get warmer too, another month and a half.
Yeah. Well, I'm down in Florida every week, so
Yeah, when do you go? You go pretty soon, yeah?
tomorrow,
It's good.
come back Tuesday.
Why did these people miss swearing in when they're on vacations and stuff like that?
Vacation, they could be sick. They could have had a fight with one of the kids.
There was no paperwork like for us.
Incarceration.
That happens. There's all sorts of different reasons.
Yeah, let's see if they can forget their paperwork. That'd be good, huh?
I think she must have grabbed it.
Did I miss the show? No. No. She's perfect. I agree. Doesn't matter, it's what it is. And folks. Duffy, down. What's going on? Little this, little that. I like it.
Bob, we're starting. Who are we waiting for? Marilyn?
Oh, good. Call on that.
Yeah, we're starting.
Just now, I did a few.
Where's Darren?
You guys are doing good.
No, we're starting.
He's a kind of asshole.
My mother always said that's
Yeah, it's what
They
it
just
is.
fish coming in here. You sign this?
But he's somebody's dad, so.
That's not me, that's up to them. Not my thing. Not my thing. That's them.
Yes, yes, it is.
I tried some.
I agree. Good point.
Hello, sir, how are you, my friend?
She didn't sneak in.
That she did.
Anna.
All right.
It is
Yes.
Early, huh? He'll be ready to go.
Wonderful.
Okay, are we ready to go? Okay, all right. Calling our assembly to order, I'd like to recognize Councilor Iannella for our prayer and pledge today.
Thank you very much, Caroline. We seek blessings on the task before us. Bless our efforts with clear insight, our deliberations with wisdom, our work with clarity and accuracy, and our decision with impartiality. Amen.
Amen. Amen.
I pledge allegiance
To the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
I recognize Councilor Duff for a motion to record advice and consent for the financial warrant.
Thank you, Governor, so moved.
Is there a second? There's a motion and a second. All in favor, say aye.
Aye.
I recognize Councilor Kennedy for a motion to record advice and consent for the pending list of notaries public and justices of the peace. Motions and a second. All in favor, say aye.
Aye.
Okay. That concludes our official business today, as we have other business to attend to with the swearing in of 2 representatives and a state senator. And as you are aware, the constitutional offices are being sworn into office as well today. So, and we have our colleagues here from the Senate. No, we have other business today.
Why aren't we voting today? We have someone on the agenda that we had a hearing last week.
It is not on the agenda
Attorney
today.
Maroney.
It is not on the agenda
Why?
today. It will be on next week.
Why?
And we are now going to
No,
welcome.
that's not the reason.
It is.
We pull them if you're not sure of the vote.
Welcome.
Respect.
Honorable Lieutenant Governor, Honorable Executive of the Council, the Honorable Committee of the House, Chairman Carolyn Dyker from Holliston.
Welcome.
Thank you and greetings on behalf of the legislature. It's my privilege to be here and present some of our legislators for swearing in, and we're really looking forward to getting to work this legislative session and doing the important work of the Commonwealth. So it's wonderful to be here, and I'd like to present our legislators, Representative Denise Provo from Somerville, Representative Sean O'Connell from Taunton, and Senator John Kennedy from Pennsylvania.
Well, welcome. On behalf of our administration and the Governor's Council, we're thrilled to have you here today to begin for you your next term of office. Congratulations to each one of you, Representative Provost, Representative O'Connell, and Senator Keenan. We have, do we need to certify the vote? Okay. So we can then turn it over to the Governor for the official swearing in.
Good morning. I would like you all to raise your right hands and repeat after me. I state your name.
I, Denise Provo,
Do solemnly swear
do solemnly swear
that I will bear true faith and allegiance
that I will bear true faith and allegiance
to the Commonwealth of Massachusetts
to the Commonwealth of Massachusetts
and will support the Constitution thereof.
and will support the Constitution thereof.
So help me God.
So help me God.
I state your name.
I, Denise Provo,
Do solemnly swear and affirm
do solemnly swear and affirm
that I will faithfully and impartially
that I will faithfully and impartially
discharge and perform
discharge and perform
all the duties incumbent on me
all the duties incumbent on me
as, state your title,
as state representative
according to the best of my abilities and understanding,
according to the best of my abilities and understanding,
agreeably
agreeably
to the rules and regulations of the Constitution
to the rules and regulations of the
and
Constitution
the laws of this Commonwealth.
and the laws of this Commonwealth.
So help me God.
So help me God.
I state your name.
I, Denise Provo,
Do solemnly swear
do solemnly swear
that I will support the Constitution of the United States.
that I will support the Constitution of the United States.
These guys need to sign this?
Yes.
Yeah. We get you guys. We get you guys.
Girls here.
We need you to sign these.
It's not official.
You're not volunteering your service, although you're a very dedicated public servant. Okay.
Congratulations.
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 Thanks very much.
Yes.
Happy New Year.
Yes, ma'am, nice to see you. Congratulations. Yeah. Yes.
Last week, 2 weeks ago.
Secretary of State will be here shortly.
I'm attending, I'm coming. I'd like to be mentioned. I'd like to be mentioned in your remarks. This is the only guest. This is the only guest. Plus his wife.
Is he going to bring the certificates? Does he ever take the one he needs to sign?
God, I would hope so.
He didn't for us guys. He had to borrow my phone to call his office.
You guys are terrific.
I didn't get it. I did not get it.
Thank you. Enjoy it.
Can I do that?
Oh, I can hear you. Yes, see you. See you in there.
Okay, this is a yes.
What?
I had a sparkle on my cheek.
Oh, except for her makeup, she put glitter in her makeup. Yeah, see that? Flicker sparkle. Very, very personal.
When I was in Florida.
Thank
Thank you.
Don't worry about it.
George, these go to you, I guess.
Yeah, thank you.
All right,
Of state, you forgot the paperwork last time.
Yeah,
Don't worry about it.
Yeah. Well done today. Well done.
All right.
Marilyn, we got something here too for you.
Did you know we went there?
I heard a rumor, I don't know. I don't know anything now. You signed this last year, we need to sign it again. Take care of the fact that sign the notaries when you're not here.
I mean, no idea.
Gary, can I get one more signature?
Sure. Why don't you put absent when someone's not there?
That's all it is, not like
As far as I'm concerned, they could show up within a reasonable time. This is the notary public thing. In case there's no meeting, which there's a lot of no meetings. They should have notaries, finance.
Yeah, right. Thank you. Thanks for offering.
Thanks. Jenny, I got one more for you. That was last year's, this is a sample. Jenny, this is what you signed last year and the year before, and take care of the fact that there's no meeting.
Happy to do it.
Happy to have no meeting, right?
Ah, you know it. I was counting up the number of rides that I've put in over the last few years.